This is Court Watch with Alex Sawyer, and I'm excited to bring you the latest episode of my podcast where I am joined by Carolyn Shapiro, a professor at Chicago-Kent College of Law and a former clerk to now retired Justice Stephen Breyer. She'll comment on a major case heard January 17th over agency discretion. But I'll also ask her about the justice's upcoming arguments February 8th over former President Trump's challenge to being kicked off the Colorado ballot. Professor Shapiro will also highlight a dispute over bump stocks and another legal battle involving social media companies and censorship laws out of Texas and Florida. Both will be argued in late February. I'm also asking her if she thinks the High Court will have time this term before they wrap up rulings in June to hear a challenge over Trump's claim of presidential immunity. Hi, Professor Shapiro. Thank you so much for taking time. I know you're very busy, so I won't hold you but 15, 20 minutes to hopefully break down some of the biggest news we've had at the start of this year for the Supreme Court. And I thought when I first came back in October with this term that the case heard January 17th over Chevron deference, basically dealing with fishermen challenging a regulation that they have to pay for a federal monitor on their vessels. I think it's like a little over $700 a day. They're challenging that rule, and at the heart of it is some precedent. But I thought that was going to be the biggest case of the term. But now that we also have the Trump Colorado ballot issue coming up, I don't know, that might be taking, the cherry on top of this term. So we'll wait and see what you think of that. But I guess let's go ahead and just start with the Chevron case, the January 17th. I mentioned the fishermen have made this challenge. The heart of it is a 1984 case. For our listeners who aren't familiar, the Supreme Court had ruled in that one that when a law is passed, if there's any sort of ambiguity, it's up to the agency to fill that in so long as it's reasonable. Am I messing something up there? Is that correct?
That's basically right. I mean, the idea is that well, first of all, thank you for having me. But the idea is that when Congress passes a law and gives power to an agency to apply it and enforce it in different circumstances, it's basically saying to the agency, look, if there's some ambiguity in the law, we are just delegating to you the power to resolve that ambiguity. So there are examples that I think are pretty easy to understand. For example, in the Fair Labor Standards Act, the Fair Labor Standards Act is the law that provides for minimum wage and overtime for most employees. But there's an exception for administrative, executive, and professional employees. Those employees are not entitled to overtime and minimum wage protections. So what does that mean? That's not a self-defining term. Congress also gave the Secretary of Labor the power to write regulations applying and enforcing the law. And so the regulations explain what those terms mean. They remained the same for a long time, but then in the early 2000s, the Bush administration said, you know what, these old regulations that really date from, I think it was the 1940s, are kind of out of date. And so they revisited them and brought them up to date to reflect our modern economy. So that's the idea of Congress doesn't have to go back and then revisit every element of every law as things change, or for that matter, as we have elections and different administrations have different policies that they might want to emphasize more worker protections or less worker protections, depending on the policy of the president.
I know during oral arguments, I left feeling like the majority of the court, they were skeptical of the past precedent. I know the issue is whether or not to overrule it, but Justice Kagan raised issues with why would we not want experts in those agencies filling in the blank? Why would you want a court to do so? Or that sort of thing, I guess, is what she was kind of hitting on. Do you think that there's a more narrow ruling the Supreme Court could come out in this one where they don't necessarily overrule Chevron? Or what did you take from oral arguments?
Well, I have to confess, I've read about the oral argument and I listened to part of it, but I did not listen to all 3.5 hours.
They're very long these days. The new setup has them very lengthy.
Yes. But based on what I've learned about what happened at the oral argument, I think there are a variety of potential outcomes here. I think it's likely that there will be some narrowing of the Chevron doctrine, at least to some extent. And there's already room in the law for the courts to say, this is a broader delegation to the agency or a narrower delegation to the agency, and how much deference the courts give to the agency interpretation might depend on the understanding of how broad the delegation is. Mm-hmm. So I think the example I already gave is an example of a reasonably broad delegation, that there's an understanding that these types of employees don't get these protections, but figuring out exactly who that is going to be for the Department of Labor. In another situation, it might be that there's a narrower range of types of decisions that the agency can make, and it might also be that there might be other types of limitations. So, for example, if the agency, in this case, is imposing a rule that affects its own ability to function, or that is construing the scope of its own powers, you could imagine the court saying, well, maybe in those circumstances, there's going to be less deference. So there are a lot of things the court could do that would narrow how much deference the agencies get without disrupting what has been a pretty stable and important element of American law for 40 years. And, I think there was definitely concern at the oral argument, certainly by Justice Barrett, for example, about just how disruptive it would be mm-hmm. to completely overrule Chevron. And I'll just want to explain that for a minute. It means there are maybe 2 or 3 points that I think are really important to understand about that. One is it means that for 40 years, the courts have been approving things that agencies have done by saying, yes, that was reasonable. And now we don't know what any of that precedent will mean. That was one problem. Another problem is that for 40 years, Congress has been passing laws on the assumption that they are going to be able to be implemented by agencies with the background of Chevron. Mm-hmm. So Congress has been operating on that assumption. And the third problem really goes to the merits of Chevron, which is that if the court is the one that says, no, we decide what the statute means, that's our job, we're going to decide what administrative, professional, and executive employees mean, then that freezes that interpretation in place and doesn't allow for the changes that we currently do allow for, which is allowing an agency to use its expertise to note that things have changed in the world and that perhaps we need to update our understanding to reflect, as I said, for example, our modern economy, or to allow for a presidential candidate to run on a platform of greater regulation or deregulation. Mm-hmm. In fact, Chevron itself was a case about deregulation and, loosening up pre-existing regulations. All of that would disappear. And I think there's a lot of concern among some of the justices about that.
Due to time, I want to move to what I kind of teased, the February 8th arguments that are coming up with the former President Trump bringing his appeal to the Supreme Court over Colorado Supreme Court's ruling. I think it was a 4-3 ruling that removed him from the ballot there based on Section 3 of the 14th Amendment, what's been known as the Insurrection Clause, which basically says anyone who's participated in an insurrection or led a rebellion is banned from holding public office. So with that background, I know there's been several other states that courts have considered this and they've either gotten rid of it, saying I think Michigan said it wasn't quite ripe because it was a primary ballot, not the general election. So they kind of ducked it for the time being. But Colorado went ahead and made this ruling. It's a big deal. Obviously, it could determine the GOP nominee. All these primaries are going on. So let me ask you, I don't know if I want to ask you what you think the court's going to do with it since we haven't even had arguments yet, right? But how quick can they issue an opinion on this given we've already had Iowa caucuses, New Hampshire, that sort of thing?
I think they can issue an opinion very quickly. They did that in Bush versus Gore in 2000 in a matter of days. And they certainly want to do that. That we know that, I think, because they set such a short briefing schedule and such a short date for oral argument, February 8th. And I think that's a very good thing. There's an amicus brief that was filed by 3 election law experts who are not ideologically aligned in all kinds of ways, but they say, look, the most important thing here is that the court actually reach the merits and resolve this long before the election. Mm-hmm. And I agree with that. I think there are ways the court could punt, and I think that would be a big mistake. I think they need to resolve the underlying question now so that everybody knows whether or not Trump is eligible to be president again. There are, I think, arguments both good and bad on both sides of the merits argument, and I don't know that I have a strong prediction about which way they will come out. I do think that the chief undoubtedly has two very strong desires here. One is that there not be a 5-4 decision, and the other is that there not be a partisan split. So he doesn't want to see a 6-3 partisan split on the outcome of this decision. So what will it take to get something that meets those criteria and reaches the merits? I don't know. I could imagine a variety of different potential outcomes. And you might think, well, are those even legitimate considerations? Is that, how they should go about it? And I do think in this instance, those types of institutional considerations actually do appropriately play a role in what the court should do.
Right. It's highly political, obviously. The country's very divided. But then, going forward, it sets precedent from here on out. So. Yeah.
So, I'll just say a word or two about the merits. Just in terms of the language of the 14th Amendment, the relevant language, there are a couple of arguments that I think are relatively easy, right? Does Congress have to act in some way? I think the answer to that is pretty clearly no. That's what I'm persuaded by those arguments. Does it apply to the president? There are some arguments about that. I think it makes no sense, in my view, that it wouldn't apply to the president. Did Donald Trump engage in insurrection? Those are, I think, arguably harder questions. And whether or not what happened on January 6th was an insurrection within the meaning of the provision, and whether what he did constitutes engaging in it. One can imagine arguments both ways. I am myself persuaded by the originalist arguments put forth by a couple of originalist law professors, Will Bode and Michael Stokes-Paulson, that he did. But those are that last piece is, I think, where there's some open questions on the merits.
Well, I think it's going to be potentially the biggest case that we'll have an opinion. I guess you said the Bush v. Gore case. I think I looked back and the arguments were held the day before. They did it all within 3 days, briefing, arguments, and opinion. So I think it was within 24 hours they did turn out an opinion. So we'll have to see what happens with this one. Let me ask you real quick. Later in February 26th and 28th, there's two cases that I'm keeping an eye on. One is the February 26 cases are the social media laws that were challenged by NetChoice. So it was Texas and Florida. They both passed laws. They were saying there was censorship from big tech companies, social media against conservatives. I think the Florida one focused on deplatforming politicians, whereas the Texas one was a little bit more like what was being removed, I think, if I recall correctly. Tell me if I'm wrong. Those are First Amendment challenge. These social media companies are basically saying, these laws don't pass muster. We should be able to, based on it being a private company, do what they need to do based on their terms. Then I'll quickly add the 28th, there's a Second Amendment case involving bump stocks. And it was actually the Trump administration that had moved to ban bump stocks. I believe it was after the 2017 mass shooting. Was it, I might have my dates wrong, out in Las Vegas.
I think 2018 in Las Vegas, yeah.
Yes. So that was, then I think it was a gentleman out of Texas. He handed over his bump stocks, but then he sued and said it was a Second Amendment violation. I think the issue is do bump stocks constitute machine guns, which are, banned under federal law. So anyways, I wanted to get your thought on both of those, the major First, Second Amendment cases that we're going to be hearing later this, next month. And with that, I know I have about 5 more minutes of your time.
That's okay. Well, I'll take the second one first, the machine gun case. It's really, it certainly implicates the Second Amendment, but as it's been presented to the court, it's a question of statutory interpretation. Does the law that bans machine guns, does it ban bump stocks? And so it's an argument about what does machine gun mean, and there is actually a definition in the law, and does it apply to bump stocks? In some ways, it's a very important case about the what the government can do right now with respect to the laws that are on the books in terms of regulating bump stocks, but it doesn't all alone. It isn't going to resolve some of the major Second Amendment questions that still are outstanding with respect to assault weapons, for example. Those cases are still going to be working their way up, and eventually, I think the court will get involved in them. The social media cases are quite interesting because there's an argument. The argument being made by the states that passed these laws is that these social media platforms shouldn't be able to discriminate over speech. And basically they have two requirements. One is limiting the ability of the social media platforms to engage in content moderation. And to the extent that they do engage in content moderation, they have to be able to provide individualized explanations as to why they took a particular post down. There is both laws also have a requirement that the social media companies make their general content moderation policies public, and that the lower courts upheld those provisions of the law, and the court has not taken that part of the case. So, and that's I think shouldn't be super controversial. It is appropriate to require entities of all sorts to provide general information to the public about how they operate. That's sort of more or less normal regulatory laws. But the other two implicate the First Amendment quite significantly. In one sense, they involve a kind of compelled speech. As a social media platform, which is a private entity and is therefore protected by the First Amendment, can the government say to it, you don't have a choice about what you put up on your platform? Now, one analogy is to say a telephone company or an internet service provider. And telephone companies and internet service providers are considered common carriers, and they're not allowed to discriminate based on who's using them. But the key difference is that they don't involve themselves at all in the content of what is being transmitted over their platforms, whereas the social media companies do. They have content moderation. That's one of the things that they can say to their users. Come join us. You don't need to worry so much about, encountering something deeply traumatizing. For example, we take down violent videos so that you don't have to look at them if you don't want, for example, or pornographic videos. And they, of course, also have their own algorithms that determine who sees what, when. And you might not, we might have disagreements with their policies in a variety of different ways, but they are private entities, and they are, so in being required to change those policies is, they argue, a form of compelled speech, which violates the First Amendment. I think the flip side argument would really require breaking some new ground legally, but it would involve on some level recognizing the role that social media plays in our public marketplace of ideas and political speech and other forms of speech. And it is unprecedented, I think. It certainly is nothing that the First Amendment has really fully contemplated before.
Right. It's wild. I do think it's become kind of like the Wild West, right, out there. Like it's the new public square. Can the court fit the D.C. if the D.C. Circuit issues an opinion quickly on the whole presidential immunity argument, with the special counsel Jack Smith and President Trump saying he is immune from all these charges? Can the Supreme Court fit it on this docket this term, do you think, or is it? Are we running out of time?
We're not running out of time. They absolutely could decide it this term if they want to. And I think it's plausible that they won't. I think the D.C. Circuit is highly unlikely to say that the president has absolute immunity. I assume the president will ask, or the former president, will ask the D.C. Circuit to take that case en banc, the whole court. I think that will be decided very quickly. I think, again, highly unlikely that they'll take that. At that point, the Supreme Court could decide they don't need to get involved because the arguments that a president is absolutely immune from everything that they do while they're in office unless they're impeached for it is, frankly, makes no sense. It just can't be the case. It would mean that, the last weeks of a presidency, the president could do whatever he wants, completely whatever he wants, without any possibility of any prosecution but then because there wouldn't be the possibility of impeachment and conviction.
Mm-hmm.
So I think it is just a completely implausible argument. And I don't think that the Supreme Court will feel that they have to get involved. So they could just say no.
Yeah, so they wouldn't weigh it. And then I guess the trial at the lower court could begin, which was set for March, but might be slightly delayed based on timing.
It's possible. I mean, it depends on how fast the D.C. Circuit acts, and then how fast the Supreme Court does whatever it's going to do. Trump and his team, they see an advantage in delay, so they will take advantage in every way they can of sort of
pushing this closer to the election.
Dragging it out.
Yeah, right.
Yeah.
Well, I appreciate your time. I know you have to go teach, so thank you so much, and I'll have to have you back on once we get some of these big opinions.
Thank you so much for reaching out. It was a pleasure.
Thanks for tuning in to the latest episode of Court Watch. If you have not subscribed yet to this podcast, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.